So I have to continue with this heading, right? Rules of interpretation or construction. So I request to highlight this line. Rules are considered as guides only and not inflexible, which means இதுக்கு பதிலா அதை யூஸ் பண்ணிக்கலாமா? It's not in that way. Okay. There is no particular sequence or there is no particular rules like wherever it is necessary, accordingly I have to use it. Okay. Right? So we have all these primary rules and secondary rule. I have given a small intro of this. So we'll come across 1, 2, 3, 4, 5, 6, 7 primary rules. Okay. So let me go for this one. So you remember this example we were discussing? Yes. No vehicles allowed in the park. Okay. This is covered under rule of literal construction, which means seeing the word, what you understand. No vehicles are allowed in the park. That's it. Go for the very simple meaning. That's about literal construction. Whereas, if you talk about the third one, no vehicles are allowed to park in the market area. There is one provision. And there is also another provision saying that vehicles carrying essential supplies may enter the market. ஒரு ஆக்ட்ல ரெண்டு different provision இருக்கு. See, one single word, in case there is a word A is a word of alphabet. A, if you see separately, is a alphabet. A is a English alphabet. Whereas if you come along with the phrase or the sentence, you'll call this as a word. Okay. So there are two provisions. Even for a single A is given importance means there are two provisions containing so many words. Which means what? Both has to be given equal importance. You cannot say this is valid and that is not valid. You cannot do that. You have to consider that both are valid. See in this angle, no vehicles are allowed to park in the market area. Yes, why? Traffic jam. Okay, we'll face so many issues and there'll be no cleanliness, etc., etc. What the next provision says? See, if you're not allowing any vehicles to park in the market, means how they'll bring the essential supplies. So, vehicles carrying essential supplies may enter the market. Both are it. Now come for the next case here. No vehicles allowed. Okay, this is about harmonious construction. Okay, let me finish off this one. Sorry. Under which it falls down. This is called as rule of harmonious construction. Harmonious means you have to give equal importance to both. Whereas if I go for this one, I'm highlighting here, no vehicles allowed in the park. Okay, we understand. But if anybody is not well or falling ill or something like that, okay, so what do you have to do? You have to get inside to get the person out. You may again ask me, சின்ன வழியா இருக்கு எப்படி போறது? vehicle போட முடியாதுன்னா okay, பெரிய பெரிய கேட் எல்லாம் இருக்கிற பார்க் இருக்கே. So in that case, emergency vehicles can make to get inside. Okay, then it's fine. Which means what? It's called as, understand the word, rule of exceptional construction. It's not mentioned in the act, but it's understood by meaning. Rule of exceptional construction. Okay, so this is 3 cases. So apart from this, so 3 are over. Apart from the second one, rule of reasonable construction. Any person who draws a weapon in the public place shall be fined. Okay. ஒருத்தர் வந்து பட்டா கத்திய சொல்லிட்டு வர்றாரு. அப்படியே அங்க ஒரு ஃபைட் நடக்குது. எடுத்து வீசுற என்ன ஆகும்? Okay, it's illegal. They are not allowed. What do you understand from this? Any person who draws a weapon in a public place shall be fined. This draws normally has 2 meanings. Draw a figure, what you do? Draw a knife, what you do? You draw a knife. See, this drawing means taking from the pocket, or this is maybe what? Artist drawing a picture. Okay, so any person who draws a weapon in a public place shall be fined is not correctly defined. It has 2 meanings. One meaning is what? Drawing, taking a weapon. That is not allowed. You have to go for reasonable construction. If any person drawing or an artist drawing any picture or something like that, then you say that is valid. He can do that. He's an artist. Okay, yeah. That's about reasonable construction. See, first, we follow the first one, rule of literal construction. If the meaning, if the grammatical wordings are very much particular, directly gives a meaning, don't get confused. Take the meaning. Okay. If not, then go for reasonable meaning. Both seems to be reasonable. See, the third case. Both seems to be reasonable. What do? You give validity for both. Because a word is there in the act means it's given so much importance that you have to treat that both the words will be valid or not. Okay. Fourth one. This happens in the case of labor protection and women and child welfare laws. So this is like called as mischief rule. Okay, let me go that a bit later. Fifth one, rule of beneficial construction. Woman workers shall be entitled to maternity benefits. What do you understand from? What do you understand from this? See the literal construction. Basic thing is you have to see the literal construction. What do you understand from this? Women and workers shall be admitted to maternity benefits. Okay. Women workers shall be admitted to maternity benefits. There's a woman worker working in my organization for 10 years. Okay. She joined soon after she finished her UG. She's associated with our organization for 10 years. She's now 31, got married, and she's about to deliver a baby. Shall I give maternity leave? Yes, obviously, I have to give as per the law, and I give. In case there is 1 year before a lady joined, girl joined, got married, and now she is carrying a child. I have to give the maternity benefit, maternity leave as per the law. Will I give? Women workers shall be admitted to maternity benefit means who are falling under women workers? Who are falling under women worker? Idhula nama question. Women then are falling. I'm not asking it that way. Probationary period workers will be there. Like temporary workers will be there. Permanent workers will be there. See, this benefit can be availed only by the permanent women workers or all the women workers. Law is not clear on that, right? But beneficial construction says women workers maternity benefits. Then whether she's just joined the organization or 10 years before she has joined the organization, whether temporary or casual employee or permanent, whatever it is, if she is falling under women worker, give her the maternity benefit. Over. That's about C. Now read the line. What is the heading? Rule of beneficial construction. See, law is for two reasons. One is to protect ourselves, especially one is to protect the others, then to protect ourselves. And we have to give benefits to எல்லாரும் பிரின்சிபல் ஆஃப் நேச்சுரல் ஜஸ்டிஸ் அண்ட் பிரின்சிபல் ஆஃப் ஈக்வாலிட்டி எல்லாருமே ஈக்குவல் இல்ல எல்லாரையும் ஒரே மாதிரி தான் ட்ரீட் பண்ணுவோம் ஓகே ஸோ தட்ஸ் அபவுட் சிக்ஸ்த் ஒன் அண்ட் செவன்த் ஒன் sorry sixth one rule of exceptional construction we have discussed and seventh one see there is a company which sells onion potato tomato and other vegetables okay what are the other vegetables you know பாவக்காய் அவரைக்காய் என்னன்னா போட்டுக்கோங்க if they say other vegetables means all other vegetables included. You go to vegetable market, what are the things you get? Okay, usually tomato is always a issue. Tomato is fruit or something. Okay, turmeric again an issue. Turmeric has medicinal properties, so it has to be treated as medicine or for cooking. Okay, again coconut oil. Coconut oil always a confusion, and our India is having different culture. Why you use coconut oil? For hair. You go to the Carolites, they say coconut oil is edible oil. Okay, so coconut oil has two different properties. It can be used for hair, that is for what medicine like purpose, skin purpose and all. And turmeric also same, tomato also same. Okay, now tell me, let me clean the board. Now you understand in this sense. I sell tomato, I sell pomegranate, I sell Mozambique, then other what? If I say and others, see I write this way. Tomato, okay, pomegranate, apple, satukuri, Mozambique, and others. What will be included in others? All of them, grapes, etc., etc. Now, onion, potato, tomato, and other vegetables. Which means what do you include in this? Vegetables. See, seeing one thing, probably if we discuss for the first line, I'm talking about tomato. Here, tomato is carrying two different angle. So if I talk about tomato, then I go for apple and other fruits. Means what are others covered? Only fruits are covered. Whereas if I talk about onion, I talk about tomato, I talk about potato, then what are others covered? Anda varaka, inda varaka, ellame covered. We talk about vegetables. See, this is what you call as depending on the genes. Genes means what? Same, similar character. Rule of existence generis of the same genes. Okay. So whenever you see a line, all these 7 points has to come in your mind. First, which point has to come? Go for the plain meaning. Now let me focus on this line, this column. See, I started this way. I asked last class. I asked you to. Uh, I discussed on this example column. I asked you to refer this case laws. Now I started with an example. I tried linking with the different rules. Okay. Now I'm giving the meaning for this. When you say literal construction, go for the exact words. Go for the plain. Don't think too much and all. What is given? Take a simple meaning. ஓகே. அங்க இருக்கிற ஜட்ஜ் எல்லாம் நம்ம ஆளுங்க தான். நம்மள மாதிரி தானே படிச்சுட்டு இருக்காங்க. ஓகே. அவங்க எல்லாம் பெரிய யூனிவர்சிட்டிஸ் அப்படியெல்லாம் இல்ல. நார்மல் பீப்புள் தான் அவங்களும். When they take that role as a judge, they become the king like அவ்வளவுதான். So go for the plain, ordinary, and grammatical meaning. What's the second one says? See, first one mandatory. If first one is not working out, then you have to go for other cases. What's the second one says? So there's no sequence, there's no order. Okay. Hereafter you can take anything. Reasonable construction. You construct it. What do you mean by what do you mean by construction? Last class we will discuss. Interpretation, construction. What is interpretation? Applying. Just applying. What is construction? I'm checking whether this will be covered in my case. So go for how far this is reasonable. How far this drawing is covered in my case, in the artist case. ஆர்டிஸ்ட் நான் ஒண்ணுமே பண்ணல சார், நான் டிரா பண்ண சொன்னாங்க டிரா பண்ணேன் சார். இந்த வால் ஆர்டிஸ்ட் எல்லாம் இருக்காங்கல்ல, வால்ல வந்து இதை கொடுத்தாங்க டிராயிங் பண்ண சொன்னா பண்ண அவ்வளவுதான் சார், இன்னுமே தெரியாது சார். Okay, probably there are some movies coming with showing with knives and other things around. He has to draw the posters of that heroes, of the characters. So what he will do? Okay, we need not think things on the political side. We need not think. If you talk about political side, it will be totally different. Okay, so I'm not talking about the political side. I'm a normal artist who draw on the. I'm a normal wall artist who draw. So this drawing is not the drawing here. So you have to give the reasonable meaning, which means you have to construct the meaning. Plain meaning is not working out. What you have to do? You have to construct the meaning, which means how you construct. நம்ம இஷ்டத்தை construct பண்றதா இல்ல. You have to give the purpose and what is the intention behind this law. This provision is made, and you give the sensible meaning. Okay. Third one, harmonious construction. We get two provisions, and two provisions has to be equally validated. In the case of more than one interpretation, both are valid unless absolutely unavoidable. You cannot avoid it, there are no issues. You have to. Why you do this? To harmonize. Harmonize means to equate. Fourth one, in the case of labor protection, women and child welfare laws, we have separate acts. So many things we have. We have ESI. All these are there. See, we have something called as Constitution of India 1915. Then it talks about fundamental right. Okay. Even though there are fundamental rights defined in our constitution, in our charter document, we have a separate act for ladies. We have a separate act for women. We have a separate act for child protection. So many things are that necessary? Yes, they are necessary because sometimes they are maybe giving some mischief, which means what we have to take the remedy. So that's about the mischief or hidden skills. I'm looking after the remedy. Okay. Fifth one, rule of beneficial construction, which means it should be a benefit for all. Which women workers are covered under maternity benefits? Even the woman who joined yesterday. Yes, she is covered. Okay. Next, exceptional construction. Exception is carved out. Please highlight this line. Carved out. Probably I'll share this one. I have shared this one, right? Exception is carved out. What do you mean by carving? Carved applicability. Which means what? It will not be there. You have to find the real meaning. Why? Because you have to go for the exceptional case. No vehicles allowed in the park, which means emergency vehicles are allowed. You have visited so many parks, right? நிறைய பார்க் விசிட் பண்ணிருப்பீங்க. என்ன யூஸ்வலா பார்த்திருப்பீங்க? What type of vehicles you see inside? Tricycle. Small kids drive the cycles. Or else, if it is a very big park, you can find the office vehicles inside. See, that's sort of restricted vehicles they can go. Office vehicles, no problem. What about tricycles? Kuttis driving. Okay, probably if you allow tricycles, next ஒரு 10 வயசு பையன் வந்து சைக்கிள் டிரைவ் பண்ணிட்டு இருக்கும். ஓகே, ஸ்லோவா டிரைவ் பண்ணுவோம், சீட்ல உட்கார மாட்டாங்க. Okay, see what happens is emergency vehicle is understood. See, emergency vehicles are allowed in the emergency situations of carving. Carving means what? You're trying to bringing out something hidden there. Okay. Then onion, potato, etc. This is about rule of adjustum gens. Okay. If all these three columns are okay, can you go for this last column? This last column is about the legal case law. I have just given a few points on this. If you have referred in earlier class, earlier home assignments, then it's fine. Else I'll discuss. I request you to go through at least a bit. So let us go for the first case law under rule of literal construction. You see the literal meaning, okay? Uh, Here actually there was a case where a vehicle was seized, which means confiscated. There is actually two meaning. One is seizing and one is confiscating. Okay, this comes under criminal law. Okay, what do you mean by seizing? Seizing of vehicles. What do you mean by that? It will be taken by the authority. Okay, what do you mean by confiscation? Means it's just a process before seizing. Okay, they will take it. Seizing means the full control will be going to that particular authority. Confiscation means they take over, but the control will not go. Vehicle is seized, which means confiscated. Okay. As per the Indian, why it is seized? We need to get the reason, right? As per the Indian Forest Act 1927, if any vehicle is carrying overweighted vehicle, any vehicle is carrying above the mentioned weight, above the maximum limit of weight, then that overweight vehicle will be confiscated, seized. Okay. So what happened in this case is this went to the court of law and the High Court ordered for fine 50,000 rupees in lieu of confiscation. வண்டியை கொடுத்துருங்க ஓகே அப்பதான் பெனால்டி கட்டிட்டு போகும். What do you understand? Please try to link with this rule. What it says? What is the direct rule? Rule of literal construction. What is the meaning over there? Confiscate the vehicle. There's nothing mentioned about the fine. But High Court order what it did, what the High Court did. It levied fine in lieu of confiscation is not the provision there in the act, so it cannot be done. So the High Court order was wrong because it was not giving the meaning. What's the meaning? Confiscate. There is nothing mentioned against penalty. There is fine, monetary fine. If nothing is mentioned, how you can give them? See, even the High Court never get the authority to give the fine penalty. Okay, whatever is there in that, it can just follow. Okay, so that's about the first one. Second one, here is one person called Harbhajan Singh. I have taken this Harbhajan Singh case in two cases. This is from state of Madhya Pradesh, such as Hazard Bharat Financing Company. Here is also I have taken the same thing. Okay, this one person Harbhajan Singh from this Hazard Bharat Finance Company, he took a vehicle, a lorry or something like that. Okay, under a hire purchase agreement. So you might be knowing what is a hire purchase agreement. So when you go for hire purchase agreement, who is the owner? Harbhajan Singh is not the owner. This company is the owner. Okay, financing company, right? Financed for hire, financed and he falls under hire purchase agreement. And Harbhajan Singh was actually smuggling here. Okay, as per the Madhya Bharat OPM Act, if any smuggling, see OPM is illegal drug. So if any smuggling is done, means we can seize the vehicle, confiscate the vehicle, and that vehicle was confiscated. Whose vehicle is that? Not Harbhajan Singh. He is the owner. Owner had no knowledge of smuggling, so had to go for reasonable construction. ஓனரோட வெஹிக்கலை கன்ஃபிஸ்கேட் பண்ணோம் இருக்கு law. As per the Madhya Bharata this act, as per Madhya Bharat OPM Act, ஓனரோட வெஹிக்கலை கன்ஃபிஸ்கேட் பண்ணணும்னு இருக்கு. ஓகே, ஆனா ஓனர் ஹர்பஜன் சிங் இல்லையே, ஹர்பஜன் சிங் தானே ஸ்மக்லிங் பண்றான். யார் ஸ்மக்லிங் பண்ணாலும் அவங்க தானே ஓனரா இருக்கணும். அப்ப இந்த கேஸ்ல அவங்க ஓனர் இல்லைன்னா இவன் தானே ஓனர், சோ கேனாட் கன்ஃபிஸ்கேட் law வந்துச்சு. So it is whose favor na Azad's favor. Case filed by state on whom? The finance company. Okay. High Court gave the High Court means High Court of Madhya Pradesh gave the order that the vehicle has to be confiscated, and this in revert. Okay, which means they went for an appeal. Supreme Court says no, owner had no knowledge of smuggling, so owner vehicle cannot be confiscated. If the owner is Harbhajan Singh, then it can be confiscated. Okay, so this was the case. See, whenever a law is formed, means there should be some reasonable construction. Why and for what purpose it is formed. Okay. Third one, actually we have two provisions and they have to be harmonized, which means they have to be given equal in meaning. Come for the first one. Article 25 2B of the Constitution gives every class of citizen has a right to enter a public temple. We have discussed this already. Last class we have discussed it. What Article 26B says? Denominational temples have the right to manage their own affairs in the matters of religion. Only Hindus allowed inside that main Garbhagriha. That's all there is. Both are accepted. You cannot say Christian or Muslim not to enter the temple or other religions. We cannot do that. But to the main Garbhagriha, there is some formalities. There is this religious culture we are personally following this. Please follow them. And other religions are not allowed. Please don't allow them. Give respect to that. So both are right. Which means what? You're harmonizing the law. Harmonizing means giving equal meaning. Which means there should not be conflict. Actually, there's a conflict, right? என்ன லா சொல்லுது உள்ள விடலான்ட்டு நீங்க என்ன சொல்றீங்க உள்ள விடக்கூடாதுன்னு அப்படி சொல்லக்கூடாதுங்கிறதுக்காக right. Then fourth one, mischief case. Here from workmen of this tea estate versus management. There is a Damachi tea estate. The case was filed by the workmen on the management. So workmen of Damachi or something like that, tea estate versus management. Here the case law falls as whether a doctor will be covered as a workman under the act. Whether a doctor will be covered. Here we have to check. Why is this? See, this is a mischief rule. Means usually we have to ask. This is also called as a forward test. எதுக்கு இந்த act வந்துச்சு? Okay. What was the earlier act? We have to check. So it's like a 4 test question. We have to check. And now we talk about doctor. We have a protection act means why this law is giving protection? அவங்களாம் தாழ்த்தப்பட்ட ஜாதி இல்லைன்னா அவங்களை கண்டுக்கிறதுக்கு ஆளே இல்லை 10,000 employees will be working in a factory. Okay, in a factory premises. If any one person gets affected, என்ன பண்றீங்க? Okay, you will not care, right? As a management, you think you will not care. இன்னும் ஒரு 5 கோடி ரூபாய் கொடுத்தா உங்களுக்காக தானே இது இருக்கு இந்த ஆக்ட். Doctor is not falling under the workman's only resign பண்ணிருப்பாங்க. So the act gives protection for the employees. It's not a remedy to exploit. Okay. So labor protection, women and child welfare. So who are covered is somewhat important. Next, fifth one, rule of beneficial construction is women workers. When we talk about ESI Act, it's a welfare legislation. So when we say something, whether the employees will be covered under or not, yes, we have to give the benefits of insurance. ESI is Employee State Insurance Act. Okay. So this is an act. It's for the benefits of all. Benefits for all. Whereas to go for the sixth one, I already discussed this Harbhajan Singh hire purchase agreement case. Here, under the MP, Madhya Pradesh Money Lenders Act 1934, whether hire purchase agreement is a money lending act or not. They say it's not a money lending act because hire purchase is totally a different case. Okay, so it should not be considered as that. So no vehicles allowed in the park means what? We say, except emergency vehicles are allowed, which means you have to carve out the meaning. So when we say hire purchase, see, this person, Harbhajan Singh, has got the money from finance and has got the hire purchase agreement entered between. And what he is doing, he is giving the money in installments, right? So if we giving the money in installments, we are returning for the amount, means should it be treated as money lending? They say no. உங்களுக்கு மாசம் மாசம் நான் 10,000 ரூபாய் கொடுத்துட்டே வரேன் அப்ப நான் உங்ககிட்ட கடன் வாங்கியிருக்கேன்னு அர்த்தமா? That's what they say. There can be any reason, no? So hire purchase is not falling under that case. So hire purchase agreement is not a money lending act. Okay, so that's about exceptional construction and aegis of genesis. Yeah, this is a beautiful case. Powell versus Kempton. See, all the 6 cases I have taken the Indian case was. This one alone, I thought this was very beautiful to discuss. So I thought I can go for English case law, England case law. In England, we have this act called as the Betting Act 1853. Okay, it says that betting is unlawful to keep in house, office, see, onion, potato, tomato, and other vegetables. So you cannot do betting, which means if you do betting in office, house, room, and other places, means it becomes unlawful. Okay, what do you understand from this? Here, the betting was carried over in open air, which means that's a ring called as Tattersall's ring. Okay, that's an open air place. Whether this is unlawful or not, how you check? You talk about house, you talk about office, you talk about room. What do you understand from this? closed area. So here we talk about open air turtle's ring. So it's not a closed area. So this is not covered, which means betting here is lawful. Okay. Yeah. So this is as per England's Act. Okay. So with the help of this, let me go from your chapter material. Yes, please join. So we'll go for only these 7 primaries for today. In the next class, I'll be completing secondary rules, aids, and deeds and documents. Okay. Yes, please. So the first one is literal construction. Please highlight this line. It's the first and primary rule of construction. Whenever you see an ad, go for the literal meaning. Probably you may get this as a quotes question. Okay. The first and primary rule of construction is that the intention, etc., discuss. Which means you're asked to write this rule of literal construction. Okay. So if the words of the statute, sometimes I have to go word by word, so kindly bear with me. If the words of the statute are capable of one construction only, it is not giving any other meaning. No vehicles are allowed in the park. Yes, it's giving a direct meaning. Don't go for any other construction. Okay, then it would not be open to the court also to adopt any hypothetical construction. இப்படி இருக்கலாமா? No, because it's clear, straight meaning. Okay, so etc. Okay, it's a cardinal rule. Please highlight this line. Cardinal rule that must be construed literally and grammatically, giving their words ordinary and natural meaning. Don't complicate the words. Give the direct meaning. Okay, அதெல்லாம் பார்த்தா see, no vehicles allowed in the park. What type of vehicles we are talking about? Okay, just imagine we are going inside a park and you find this water related areas and all for restroom and for drinking water for all other facilities. Okay, probably there may be a pond nearby and a vehicle has to come inside to clean the pond. There's a big pond inside and the vehicle should come inside to clean the pond. Is that vehicle allowed? It's not an emergency vehicle. Is that vehicle allowed? Is to keep the pond clean, I need to allow the vehicle. Okay, I need to allow those vehicles, which means no vehicles mean what are the vehicles covered? See, it's clear, no vehicles. Please try to understand. No vehicles allowed in the park, which means what? No vehicles allowed. Don't go for any other meaning. Go for the direct literal meaning, no vehicles. But you have to go for reasonable construction. So not reasonable, exceptional construction to check whether I can allow the vehicle for pond cleaning. There is no water coming on that particular day. The tank is empty. I need to buy the lorry water. Okay. அப்போ lorry உள்ள வரணும். So lorry is allowed. You cannot again say no vehicles are allowed. Say no, you cannot say that. Directly, if you say it is understood, but exceptional case also has to be taken for. Okay. So when we say ordinary or natural meaning means give the normal meaning. Don't complicate yourself. Give the normal meaning. Okay. So I had to take in the grammatical sense. Okay. So if the phraseology, please try to understand. What do you mean by phraseology? Set of words. If the phraseology, we cannot say as one single word, we cannot talk about. We have to talk it line. We have to consider all the words. If the phraseology is clear, unambiguous, and capable of one and only interpretation, means then it would not be correct to extrapolate. Please highlight. கரெக்டா அது ஒரு மீனிங்கா தருதுன்னா நீங்க டீவியேட் ஆகிட்டு போறீங்க தேவையில்லைங்கிறாங்க. Please stick to that meaning. Don't deviate. Okay, when the language of the statute is plain and ambiguous, it is not open to the courts to adopt any other hypothetical construction already we have discussed. Thus, please highlight, it is a primary duty of the court to interpret the words used in legislation according to the ordinary in absence of any ambiguity or doubt. There is no ambiguity, which means what? There is no confusion. There is no doubt. Then why are you getting complicated? Why are you making it complicated? Go for the direct. Normally, where the words of a statute are themselves clear and unambiguous, then those words should be constructed in the natural and ordinary meaning. Okay, this is what we call as the rule of literal construction. So this is covered under the maxim called as absolute sentia exposure, not indigent. Absolute sentia means giving absolute meaning. This is exposure means exposing. Okay, giving absolute meaning means absolute sense. Giving absolute sense, not indigent, which means what? Don't complicate. Don't make it foreign. Indignious. Don't make it foreign. Okay. So plain words require no explanation. Sometimes, occasionally, may arise where a choice has to be made between two interpretations. Yes, please highlight this. One is narrower and one is wider or bolder. In such situation, If the narrower interpretation would fail to achieve means then manifest purchase, one should rather adopt the wider one. One is narrow, one is wider. As we were discussing, no vehicles in the past, no narrow. But when you go for emergency vehicles, pond cleaning vehicles, water filling lorry vehicles, that has to be considered. Please consider. Okay. And when we talk about the disclosure of, this is an example, probably will follow from Companies Act 2013, Section 102. It says that the nature of concern or interest, financial or otherwise, of a director or manager of a company in the subject matter of the proposed motion. I don't know whether I have discussed this. Whenever there is a meeting held in, probably board meeting, okay, probably we are all there in the board meeting. How many? Some 10 people. Okay, for example, I take 10 people are there in the board. There are 10 directors in the board of directors. Okay, and there is a board meeting on. Here, why son is being, whether we are checking why son is being, can be taken as managing director of the company. Anyway, it will go to the AGM or AGM for the resolution to be passed. But board of directors should authorize first, right? Whether we can choose vice son as AGM or AGM. Okay. So in this case, please listen. Among the 10 directors, Y is one of the directors. நான் தான் என்ன பண்ணுவேன்? நான் தான் Y. நான் தான் என்ன பண்ணுவேன்? என் பையனை வந்து எம்டியா போடுறாங்கன்னா, let's say okay. ஓகே. ஐ மே நாட் சே ஓகேங்கிறது அது எத்திக்கல்ல வராது. ஓகே. எனக்கு ஏதாவது ஒரு இன்டைரக்ட் பெனிஃபிட் வருதுல்ல. See, that's what nature of concern or interest. So, what law says is, when you pass the resolution one by one in the board meeting, when you pass the resolution one by one, when you go for passing the resolution, whether managing director can be recommended, sorry, whether a vice son can be recommended as a managing director means this vice should not be present in the meeting. Okay, please try to understand this vice should not be present in the meeting. Which means law and we write the minutes, right? And the minutes confirm பண்ணிருக்கணும் why was not there in that meeting hall. He will be sent outside, the resolution will be passed, and then he will be called inside. This is the law. In case, just imagine, among the 10 directors, totally 10 directors, Y is there, he is a director, and X is there. Who is X? Y's son. And we are going to appoint whom as the managing director? Whom as the managing director? Whom as the managing director? X as a managing director. Y's son then X as a managing director. Here, Y should not be present in the meeting, X should not be present in the meeting. உங்களை தான் மேனேஜிங் டைரக்டரா அப்பாயிண்ட் பண்ணி நீங்களே உட்காந்து நீங்களே ஓட் பண்ணுவீங்க அவங்களுக்காக. You should not vote. Okay, so that's about this line. So that's about the full para is about. Okay. So whenever you go for expressing nature of concern or interest or financial or any type of that, as per section 102 of the Companies Act, they say any. Please highlight. What's the word here? The. But how you have to understand this? Any. Why? Here, the means I'm talking about the director Y. So, what is the concern or interest for the director Y? Appointing his son as managing director. But when we talking about that person's interest means but I'm talking about all the directors' interest. Okay, so in that case, I have to consider as any. See, is the Companies Act only for Y as the director? No. This organization is talking about Y as director. That organization is talking about somebody as a director. So we have to go for natural and grammatical meaning. We have already seen this. You can just have a look on the state of Himachal Pradesh versus Pawan Kumar, or you can go for direct these case laws law. You can highlight these case laws. Okay, the first case law, go with Singh. Okay. Then question number 2, I request you to go through. This is about the beetle leaf case. I request you to go through. And when you go for technical words, you should understand technical words in technical sense. Okay, don't give any other meaning. Okay. You can just go through this one also. So that's about the first. Can you please go? Rule of reasonable construction. According to this rule, the words of a statute must be constructed as atrus magis valem comperit, meaning thereby the words of statute must be construed, so as to lead to a sensible meaning. Please highlight. If it's giving direct meaning, it's fine. Even though it's giving direct meaning, there will be some sense or there will be some intention behind that words. So you give that intention meaning. Okay. It is only when the words of the enactment are capable of two constructions. Please highlight. Our example was any person drawing a weapon, okay, in the public place will be levied fine, okay, will be fined or something was there, okay. So here draws carries two different meanings, which means there are more than one construction available. So in that case, we go for reasonable construction, which is giving the reasonable meaning to it, sensible meaning. Okay. So, so this principle, let me go directly over here. This principle is based on the rule that the words of the statute must be, okay, not here, sorry. Here. Shall interpret the statute so as to revolve the inconsistency and make the enactment a consistent as a whole. Which means what? You should not go for that particular act or that particular provision alone. You have to consider the whole act as one single one. What is the meaning in the where meaning in the yeah. So statutes must be constructed grammatically. When it leads to certain absurdity, okay, it's not giving clear meaning, means it is permissible to depart therefrom and interpret the provision of the statute. Please highlight this line. It is not giving clear meaning. It is not giving direct literal meaning. What you can do? You can deviate from the lines. It's allowed because you have to give the reasonable sensibility. Okay. So how far you can deviate? It's not deviating, it's not completely deviating, right? How far you can deviate? Only to the extent it's such avoids such absurdity and no further. Only to that extent. So the court will check. It will check the provisions, whether it will check whether it's giving a plain meaning. It is giving a plain meaning, but it's not fair or is not giving a reasonable construction. Means then the court will depart. Which means what? Court is given the authority to depart. Which means what? It has the duty to depart. It is duty. It has to depart. Okay. So that's about the second rule. Second rule is about rule of harmonious construction. Rule of harmonious construction. It is recognized rule of interpretation of statutes, not only that, even the deeds also. The opposite of harmony is conflict. What do you mean by conflict? One provision is giving one meaning, another provision giving different meaning. So you need to break that conflict, which means what? You need to equalize that, which means you are harmonizing. That's what you call as harmonious construction. So whenever you find a conflict, then you apply this rule of harmonious construction, which means it's a process which we give the validation for both the provisions. Unless it is extremely not like unavoidable, you cannot do it, means you can move it. Okay. So what happens? When an expression is susceptible of a narrow or technical meaning, as well as popular meaning, the court will be just in assuming the legislation used in the expression in the normal sense. Okay, let me go for any examples here. Okay, there is no example. Actually, I'll just give a small example. Um, Actually, there one case happened, a case related to betel leaves. You know, betel leaves, sweet metal. There's another one biological name for betel leaves. தெரியுமா? எனக்கு தெரியாது. நமக்கே தெரியலனா ஜட்ஜுக்கு எப்படி? Okay, there was a case happening. There was a case proceedings going on. So the two lawyers they were arguing. Argue பண்ணும்போது they were using the biological name for betel leaves. Okay, biological name for betel leaves. The judge might have interpreted this way. இதுக்கு பீட்டல் வெத்தலைன்னு ஒரு லோக்கல் நேம் இருக்குல்ல சொன்னா எல்லாருக்கும் புரியல அந்த நேம் யூஸ் பண்ணுங்க சொல்லி. Okay, see now read this one. Whenever we have a narrow or technical meaning, biological name is a technical meaning, as well as popular meaning means which one will help you in understanding the case. Betel leaf is easy, right? So go for that popular meaning. So that's about the cases. Beautiful article. Okay. And it's a basic rule of interpretation that is possible to avoid. See, this is only I think sales tax, and it happened in sugar mills case also. So to avoid a conflict between two provisions on proper construction, it's the duty of the court to constitute them so that they are given harmony in each other, which means no conflict exists. So I'm not going line by line. You can manage. A specific rule will override a general rule. Please highlight. This is expressed in the maxim called as generia specialis, not derogate, which means if there is any specific rule means it will override a general rule. So which one will be prevailing? I have some provisions in MOA. I have some other provisions in AOA. Which one will which one will override? Which one will prevail? The provisions in MOA will provide. Okay, now go for the very first line here. First line, remember we were discussing here It is recognized as a rule of interpretation of statutes, not only the deeds. See, when we talk about MOA and AOA, it's an agreement like, not exactly following the agreement format. It's an agreement like where if you go for MOA, it's between company and outsiders. If you go for AOA, it's between company and insiders. It's like an agreement. What do you mean by deed? Means as per the law we have to follow. As per the conditions we agree, we have to follow. That's about MOA and AOA. So as we discuss in this manner, MOA says one thing and AOA says another one thing, means which one will prevail? This is a specific law, MOA will prevail. Okay. Again, if you talk about the Act only will prevail. Companies Act only will prevail. Okay, so let me go. So where and all we understand this one. We'll come across three cases. One is subject to, okay, one is notwithstanding, and one is without prejudice. Okay. Subject to is the first case. When a provision is used, yes, you can follow, but whenever you find this word subject to, because which means it's implying a condition, you have to follow that condition. What is read பண்ணே வரீங்க subject to இருக்கு அப்ப subject னா அது follow ஆச்சு follow பண்ணும் okay so this limitation cannot operate when the subject to of the two provisions is not same. Okay, so this is about subject to. Let us go for this one. Any change in the name of the company shall be, yes, you can change the name of the company, shall be subject to the provisions of subsection 2 and subsection 3 of section 4. This section deals with what are the names you can have for the company. Sorry, what are the names you cannot have for the company. Like having as Bharat. Okay, you cannot have all these names there. Okay, so in those cases, it given as subject to. Section 30. You remember section 30? Amendment of MOA. 13 and 14. Okay. Section 13, subsection 2 says you can change the name of the company. Even though it says you can change the name of the company, you have to follow the provisions of subsection 2 and 3 of section 4. And in case you have any approval from the central government saying that it is given in writing saying that we can change the name means, then no issues. You can follow. Okay. So this implies that any change of the name of the company has to be in accordance with these two sections of the Companies Act. So this is subject to. Next, we'll go for notwithstanding. Actually, it's a lengthy statement. We have first case, notwithstanding anything contained in another section or subsection of that statute. Please highlight this one. I'm talking about one particular section. It will say notwithstanding to another section. Okay, then I should not follow that section. I need not follow the section. First one. This is first one. Second one. Notwithstanding anything contained in the statute, which means what? Any act will be mentioned. Okay, notwithstanding contained in this Companies Act or something. So it will be mentioned. So we need not follow that. We follow this one. It is having an overriding effect. Third one, notwithstanding anything contained in specific sections or subsections. Please highlight. It may look similar to first one. First one was sections or whatever it is in that act itself. Here, third one is or all of the provisions contained in another statute. Please highlight. Another statute. Okay. First one was section or anything in my statute itself, in whichever act you are referring. Second one was totally for the whole statute. Third one is still wider. In any other statute, you said that you should not do means you cannot do. Okay, third one. Okay. Fourth one is again more wider. Not anything contained in any other law for the time being in force. Tentatively, we have a notification like some curfew is there or something like that for 15 days. For that 15 days, you cannot follow. Okay. But it says what? Notwithstanding. Generally, you cannot follow. But when we have this notwithstanding and this line, we can follow. It becomes like an exception piece. First heading was subject to. Subject to means you have to follow this condition, and following this condition, you can apply it. This second heading is notwithstanding, which means that even though another section gives another one result, this section gives another result. Don't worry, you need not take that one. This section is having the overriding effect. Prohibition of shares at discount. Two sections are there, but here it says notwithstanding. So you can follow. Okay. So that's about this one. So 4 cases. So let me go for the first example. Say I'm not dealing the full example. Okay. Anyway, I can definitely say you will not write the full example and all for example. What's the first one? Under the notwithstanding case, please join. notwithstanding anything contained in another section or subsection of that statute itself. Which means what? Which act I'm talking about? The same act. Now come for Companies Act 2013. Go for section 42, subsection 11. Here, subsection 11 starts like this. Notwithstanding anything contained in subsection 9 and subsection 10. Nothing is mentioned over here, which means what? It's talking about section 42, subsection 10 and section 42, subsection 11. இதெல்லாம் ஏதாவது மென்ஷன் பண்ணியிருந்தா அதெல்லாம் ஃபாலோ பண்ண வேண்டாம். Subsection, sorry, 9 and 10. This is 9 and this is 10. If anything is mentioned in controversy to subsection 11 means don't follow these two. Follow which one? This one, which means this is having a overriding effect. This is falling under which case? Of that statute itself. Okay. Whereas, if you go for the next one, anything contained in the whole statute, which means what? Not only this section. See, earlier we were talking about section 42 alone. But what they say here, not only for section 42, section 1, section 2, or any section, you need not follow anything. This is the overriding section. See, section 8, subsection 8 of the Companies Act 2013 says, amalgamated with any other company, etc., is notwithstanding anything contrary contained in this act, the central government may order provide for such amalgamation. There may be so many restrictions given for amalgamation case. So you might be knowing what you mean by amalgamating two companies. So X company, Y company, they are forming together, forming as XY company. Okay. So a new company is formed. Then you get an order from central government. Okay. You have to follow the central government. You need not follow other procedures. Again, if you want to change the company's name, central government says you change the company name. So you need not wait for the shareholder resolution to be passed. Shareholder resolution pass பண்ணால name change பண்ணனும்னா கம்பெனியா பட் சென்ட்ரல் கவர்மெண்ட் ஆர்டர் பண்ணிருக்காங்கன்னா ஏன் சேஞ்ச் பண்றீங்க? தட் இஸ் ஏன் ரெசல்யூஷனுக்காக வெயிட் பண்றீங்க? You can just proceed. That's why we use this word called as notwithstanding. And under which heading is false? Notwithstanding anything contained in that statute. Not only this section, any section says anything about this procedure means don't follow. This section is clearly giving the overriding effect. So notwithstanding is overriding effect. Let me go for the third case. Notwithstanding sections or subsections, anything like in another statute. Okay. Probably if we talk about Securities Contract Regulation Act, in short we call it SEBA Act. Okay. Under section 7A, we talk about the provisions. Here they say that you don't follow anything from Companies Act 1956. Over. Don't follow means what? Only for this section you don't follow Companies Act. So which section is prevailing? This is overriding, having overriding this section from Companies Act. Okay. Fourth one, notwithstanding contained anything, any other law for the time being in force. So we are talking the same, say section 8 and notwithstanding anything from Companies Act. Not only Companies Act, you can follow anything as you want. Okay. So that's about 4 notwithstanding. Probably you may get only this thing on the exam, notwithstanding provisions alone. You have to write everything in detail. Okay. So let me go for the third heading. Without prejudice. Please, I'll go word by word. It's quite important. When certain particular provisions follow general provision, and when it is stated that the particular provisions are without prejudice to those general provision means the particular provision would not restrict or circumscribe the operation and generality, which means it shall operate in addition. There is a provision which says that you have to get the resolution passed in the general meeting, special resolution passed in the general meeting. So we need to have 3/4 majority. Okay, there's a law saying. And you come for some provisions in between that, and that is adding without prejudice, which means although these provisions are followed, it says, for example, without prejudice, you have to get the central government permission. You follow all these provisions. Along with this, you do this one also. See, in addition to that, you do this one. It is highlighting in addition to that and not in derogation. What do you mean here? Act says you have to get the permission from central government, which means central government permission வாங்கிட்டோம் shareholders க்கு வாங்குமா தேவையில்ல அப்படி அல்ல அர்த்தம். See, it says in addition to that. They say in particular, which means shareholders resolution is mandatory, After that, it's because added without prejudice. We have to get, in addition to that, you have to get the central government support. For example, amalgamation. Amalgamating two companies. What happens is whenever two companies are amalgamated, especially you have to get the permission from competition tribunal. கேள்விப்பட்டிருப்பீங்க. When the company amalgamate ஆகுதுன்னா competition tribunal கிட்ட ஏன்னா competition monopoly வந்திருக்கணும், காட்டல் வந்திருக்கணும். அதனால என்ன பண்ணுவாங்கன்னா காம்படிஷன் அத்தாரிட்டி அவங்கள சர்டிஃபை பண்ணிருக்கணும். சர்டிஃபை மீன்ஸ் they have to nod, which means they can say okay. அப்பதான் ப்ரொசீட் பண்ண முடியும். So in that case, what happens is it has to be taken as additional provisions, not in derogation of the general provision. Not in derogation means what? Higher authority கொடுத்தாங்க இங்க தான் கொடுக்குது அப்படின்னு யோசி. Is it okay? Right? Shall I go for the next one? Or you can just have a look. Yes, please. Rule in Hayden's case, or what you call as mischief rule. If time permits, I request you to go for the complete case of Hayden's. Okay. I thought of taking Indian legal cases. That's why I took the other one. Okay. So we were talking about the doctor, right? The doctor's case. This was a case. Hayden's case. We need to check whether the doctor will be considered as a workman under this labor laws. So we need to check why this labor protection laws are there, why we need to have this law, what was the law earlier. See, there was something not present in the earlier law, and we need that as a remedy in the recent one. See, we have 2013 Act, Companies Act. Why we need to have this act? 1956 ஃபாலோ பண்ணலாமே. தட் வாஸ் நாட் கான்டெம்பரரி. எல்லாம் வந்து எக்கனாமிக் டெவலப்மெண்ட் ஸ்பீடா போயிட்டு இருக்கு. நம்ம மட்டும் அதே பழைய லாவே வச்சுக்க முடியுமா? உட்கார்ந்த இடத்துல இருந்தே பணம் ட்ரான்ஸ்ஃபர் பண்ண முடியுது. யூ கேன் கெட் ஆல் த்ரூ இமெயில்ஸ் அண்ட் எவ்ரிதிங் கேன் பி டன் இன் ஜஸ்ட் அ கிளிக். But still we are following 1956 Act. Earlier on to incorporate a company, we have to go for the register office and we have to go for personally submit all the documents and give everything. And it's not all necessary. And you get the certificate of incorporation by mail. Over. It's very clear. That's all because happening of this 2013 Act. So you need to get any clarification about this 2013 Act means what you do. You go and refer 1956 Act. Not in a positive way, in a negative way. That's about the mischief. Something was not there in 1956 Act and we need to have a new act which is giving remedy for that. Okay. அந்த ரெமெடி எங்க ரிசால்வ் ஆகுது 2013 ஆக்ட்ல ரிசால்வ் ஆகுதா அப்போ இதுக்காக தான் இந்த ஆக்ட் இருக்குன்னு அண்டர்ஸ்டாண்ட் பண்ணுங்க. So doctor is covered or not? Why we have this act, labor protection, to cover the laborers. Who are the laborers? See, there are so many working in a factory and one meets with an accident, working near a missionary. Okay, doctor and missionary to work பண்ண போறாரா? Why we need to talk about him then? Okay, doctor may be considered as an employee, even though he's a professional, he may be considered as an employee. Should he consider as a workman? No, not necessary. Because labor protection is talking about this related to industrial dispute and other things. Doctor is not going to get involved in industrial dispute act. Okay, so அந்த மாதிரி பார்க்கும்போது we need to resolve that case, which means we have to remedy it, resolve it. So in that angle, to check about this one, about this interpretation, we need to go for fourfold test, and that fourfold test is asking four questions. Okay, to understand this rule, we have to ask four questions. What was the law before making of this act? Okay, in that act, okay, this is second point is talking about the earlier act. In that act, what was the defect? Okay, there was something not present. That was the defect. And there was something which was not clear, or some hardship was there, which was not covering many things, or some provisions is gaining a very narrow meaning. So we have to remove that defect, which means what we have to remedy that. Then third one, how does the Parliament Act of Parliament seek to resolve or cure the mischief or deficiency? What step did the Parliament take? Okay. Then fourth, what are the true reasons for the remedy? If all the four questions are understood, then you can clearly apply this rule of mischief or Hayden's case. So you can talk about the Hayden's case. You can refer the Hayden's case later. I'm not going in detail. So where the language used in the statute is capable of more than one interpretation, then you ask all these questions and check whether this principle is applying or not. Okay. So the intention of the rule is always to make such construction and shall suppress the, please highlight, See, already we were talking about the second rule. What is the second rule? Rule of reasonable construction. There also we were saying if there is more than one construction, two or more construction means we can apply rule of reasonable construction, giving sensible meaning. What is the case here is, it's not about giving sensible meaning, it's about removing the defect. Please try to understand. Sensible meaning or defect remove from the Okay. So we have this Hayden's case. Four things, four-fold test is from Hayden's case only. So applying this Hayden's case codes will be bound to look at the statute of the law at the time of passing of the enactment and not only as then it stood. Please highlight. That வரும்போது எப்படி இருந்தது? See, we are in now 2025. When we got this 2013 Act, 10 years back, we are checking not the 2025 state. We are checking about the 2013 state. 2013 அது வந்திருக்குன்னா அந்த டைம்ல அது தேவைப்பட்டிருக்கு தானே. Okay, if you now ask, what's there, ma'am? Even now I can send an email and I can get everything done. But leave of today, what happened some 10 years back? Is that easy? You may think it's easy, but how far it's easy with government authorities? So apply the head and case. What the courts will do, what's the duty of the court here? Will be bound to look at the state of the law at the time of passing of the enactment and not only when it is being applied in the current state. Okay. But under previous statutes also, which means what? We have to look out the previous statute, we'll check what is over there, what is not there, and what is there here that. Okay. So you can just refer this Kanailal Paramnidhi case. I'm not going line by line. Why don't see, just imagine we are playing some puzzle game. Okay. We have done this puzzle. Top to bottom, one word will be given. You have to choose that word, and left to right to left, crossword puzzle. Just imagine there is one word you have found. This is letter Letter. Okay. And you found another one thing called as ATE. Okay. They're asking you to fill this one. They say it's a three-letter word. It has a second alphabet as A, so it's three-letter word. Okay. It has a second alphabet as A, third alphabet as T. Any word you can fit here. What you will fit here? If this is a situation, they are not talking about the first alphabet. They are talking about A second letter இருக்கும், T வந்து third letter இருக்கும். அப்ப இங்க என்ன fit பண்ணுவீங்க? Cat, pat, hat, tat, anything you can fit. Okay. If they give probably that three-letter word is an animal, probably you can say cat. They're not giving any hints about the first alphabet. They clearly say second is A and third is T. So if you fix this as cat, you'll not get price. How do you know that? Because the person who is conducting this competition will have the answer solution to that. He will refer the solution. Okay. He says that tat. I don't know how far tat has a meaning. Okay. He finds that T80 means you give the price. He wins in the competition, you give the price. What you feel? After seeing that, see, you have played this puzzle words. Next week only you give the solution. Or this the next day only you get the solution. So you see the solution, it gives the word tat. Okay, what do you feel? Yama transform. They have not mentioned anything about C. So which I think that cat is also there, cat is also there, cat is also there. You say cat is the solution to win the prize. I say cat, but which one has to be taken? That's about this act. See, now they say here the issue was whether the act applies to competitions which involve substantial skill and not in the nature of gambling. Whether you feed TAT or CAT or HAT, you have to give the price, right? You give a solution and you check whether this is a matching game. Now come for the last line. The act was enacted in parliament. See, authorizing parliament to pass the act. What it said, having regard to the history of the legislation, the declared object, etc., etc. Okay, whatever this, Only those competitions in which success does not depend on actual substantial degree of skill may be considered was that. This was a law passed. Only those competition with success does not depend on any substantial degree of skill. That only you can take this as competition. That was discussed in the law. That was passed in the law. That was not there earlier. Okay. This is a mischief. What's a mischief? Whether you can consider the skill or gambling. Here they say if you have any substantial degree of skill, don't consider this competition over here. It's like lucky draw. Again, the lottery tickets are not there. Lucky draw, the lucky drawing the number then. So that's about this one. So let me continue. I'll go for rule of beneficial construction. Please highlight. We may expect this as a quotes. This is strictly speaking not a rule, but it's a method how you can interpret a provision so that you will just give the declared intention of the legislation. Why the legislation is there? To benefit to those particular persons. Yes, are they getting benefits? Yes, they're getting benefits. Then apply this as a rule. Okay, it's a process. It's a method how you're going to apply. Is this not giving benefit? Then don't apply. Check whether it's giving benefit or not. That's about beneficial construction. Usually, this rule is being provided for underprivileged people or who have not been treated fairly in the past. So, like that. So, we have like the SC college and all right. So, that means. So, directly, let me go for sixth one. Rule of exceptional construction. As to give a sensible meaning is the very first one. You remember, no vehicles are allowed to park. Okay. Sorry, are not allowed inside the park. And the last one is are allowed which one? Emergency vehicle. So first one we have done. It follows that you can go for direct general meeting. But here Maxwell gave this extended one says, notwithstanding the general rule, that full effect must be given to every word. And if so sensible meaning can be given to a word or space and it would defeat the real object, please highlight, then it would rather be eliminated. Even though emergency vehicles not allowed inside the gateway and the security என்ன பண்ணுவீங்க தூக்கிடுவீங்க கரெக்டா security வந்து emergency vehicle கூட உள்ள அனுப்பலனா தூக்கிட்டு behind. Why are not allowing the vehicles inside the park? Not to create a distraction for the users. So if that is the real object, yes, please follow that. But at the same time, it's the need that the park users as a public place. You need to provide the general facilities. Okay, so in that case, you are allowing the vehicle. Yes, we can do it. ஓகே பெரிய பார்க் ஒரு வீல் சேர்ல வயசானவங்க வீல் சேர்ல உட்காரவங்க பார்க்கே வரக்கூடாதா ஓகே வீல் சேர்ல தள்ளிட்டு வராங்க வரட்டுமே that also is vehicle only how far wheelchair will be considered as vehicle actually if you go for this case law no vehicles are allowed in the park the question here was whether a wheelchair will be considered as vehicle or not which one you say as vehicle chakranga vehicle if it has wheels means vehicle whether we can consider wheelchair as vehicle or not. So one law was saying wheelchair can be considered as vehicle because it don't go for the direct literal meaning. Which meaning you have to select for? Reasonable meaning. Okay, but if you say the park is very small, if the wheelchair goes, there will not be any sufficient area for the walkers to pass by. So what can do? No wheelchairs allowed. பார்க்கே சின்னது நீங்க வீல்சேரை பிளாக் பண்ணீங்கன்னா எப்படி நடந்து போவாங்க எப்படி குழந்தைங்க விளையாடுவாங்க இடமே இல்லை இந்த மாதிரி எல்லாம் ஸ்டெப்ஸ் இருக்கு எப்படி வீல்சேர் அசஸ் பண்ண முடியும் so there are so many things that sometimes you have to eliminate the meaning accordingly. Okay. So this is the rule of we'll go for and or when to use and when to use are. What do you mean by and? It's a conjunction word. What do you mean by conjunction? Joining two things. So it's a particle joining words and sentences and is normally conjunctive. In this conjunctive sense, the word is used to co-join, which is conjoin words or clauses or sentence. Whereas if we talk about or, it's a disjunctive particle, either this one or this one. Who can sign the document or whatever the resolution? Two directors or director and managing director, for example, which means what? As per the act, we have to go for giving preference to this one only because managing director is there. If there is no managing director, you have to go for this one. Usually, what do you mean by or? Either or. Okay, either this one, yeah, it's over here. Either this one or that one, which is giving an alternative for this. You're having a common seal. Common seal is not mandatory. If not having some common seal, then two directors have to say. So you go with common seal mandatory or not mandatory. Voluntarily case, okay. If not taking as a mandatory case, you go for where two directors are signing. Okay. Now come for this line. This is often asked. Can and be read as or and vice versa. And or a treat பண்ணலாமா or and a treat பண்ணலாமா. Usually when we say and is conjunctive or means destructive, but sometimes as per the law we have to give the effect. See, we have this one, two directors or director and managing director. Which one is more effective? Director, managing director. Okay. Sometimes this or will not take the meaning or. We did in General Clauses Act. Shall is not shall. Okay, it becomes compulsory. Sorry, may is not may. You should not consider as may not. You should consider may as shall not. You have to give the strict mandatory meaning. Okay, so this is how it's dealt. Okay, so this is not as normal you can go through. See, the same thing may, must, shall. Okay, follows from General Clauses Act. I'm not going line by line. So how far they are saying it's mandatory and directory. You can just go through. Okay, so I'm not going line by line. Let me go for this heading. The question will be asked whether a statute is mandatory depends on the intent of the legislation. Whether I have to follow this law strictly, what the law says, you do that. Okay. Companies Act says a company can be formed, there is a business can be formed for doing lawful purpose. Which means what? Not for unlawful purpose. It's understood. So for any lawful purpose. Okay. So in cases where the normal significance of imperative and permissive terms leads to absurd or inconvenient or unreasonable results means they can be discarded. You need not follow that. This is what you call as construction. I'm checking whether this case is applicable to me. See, Companies Act is also talking about producer company. My company is producer company. இல்ல இல்ல கம்பெனிஸ் ஆக்ட் சொல்லியிருக்காங்க நம்ம ஃபாலோ பண்ணணும் என் கம்பெனி ப்ரொடியூசர் கம்பெனி இல்லையே அப்ப நான் ஃபாலோ பண்ணணும் Companies Act is talking about women director. Companies Act is talking about foreign director. ஏன் போர்ட்ல தான் ஃபாரின் டைரக்டர் உமன் டைரக்டர் இல்லையா அப்ப நான் ஏன் ப்ரொவிஷன்ஸ் படிக்கணும் கரெக்டா if that see provisions are there because it's an act, it's applicable to all company, but that provision is not applicable for my company. There is no managing director in my company. Then who will sign? Two directors only will sign. Okay, those provisions are applicable. That's what it calls construction. Whether this is applicable to me, okay. So that can be disregarded. If you feel that is not reasonable, means you can disregard. இல்ல இல்ல கம்பெனிஸ் ஆக்ட் சொல்லிருக்காங்க மேனேஜிங் டைரக்டர் சைன் பண்ணும் முதல்ல மேனேஜிங் டைரக்டர் அப்பாயிண்ட் பண்ணுவோம் no, it's not there. Okay. May, though permissive, sometimes has compulsory force. This we have already discussed. So may should be treated as may itself. Mandatory or compulsory, we have to treat this one. So not as normal. இதெல்லாம் நம்ம general class exactly discuss பண்ணிட்டோம். So I'm not reading line by line. Shall I finish it off? The last heading. We'll go for rule of existum generis. So already we are done with examples. Can you find any chart or something like that? Yeah, directly go for this one. When does it apply? We have a enumeration of specific words. Please highlight. Onion, tomato, potato, which means what? Onion is a specific word. நீங்க பார்த்ததுல ஆனியன் சொல்ல முடியாது ஆனியன்னா you have to have this texture, that color. Probably onion different varieties இருக்கு, that's different. But onion means seeing that you can say it's on onion. Tomato, yes, country tomato, normal tomato, but seeing that you can say it's a tomato. Seeing the color, another thing. Like potato. So tomato, onion, potato are specific words. And what you're doing, you're grouping it. See, you're separating by commas. You write onion, you write potato, you write tomato, which means what? You're enumerating. Enumerating, so that should be your condition. Next. The subject of enumeration will constitute a class or category, will fall under a. See, when you put all these, you understand this as a list of vegetables. Correct? You understand this as a list of vegetables. Which means what? All these words enumerated. First, what you have to do? You have to form a group. So, enumerating is first step is grouping. You have to check whether there is a grouping. And whether that grouping falls under specific category. This all grouping what? Vegetables. What's the third? That class or category is not exhausted by enumeration. It's not giving different meaning. Usually tomato has two meaning. But tomato understood with onion and potato, understood as vegetable itself. Okay. Fourth. Okay, it's not exhausted, which means what? Not deviated. Not deviated. Fourth, the general terms follows enumeration. Probably after that, whatever you have, it follows enumeration. And please highlight the fifth one is important. இதெல்லாம் நீங்க நார்மலா கெஸ் பண்ணுவீங்க. Fifth one is important. There is no indication of a different legislative intent. Probably onion, tomato, potato, and other vegetables except potato. We saw this example betting in England. Okay, I think house, office, room, and other places. Which was not covered? Taxel ring. Open air was not covered. It was mentioned, example, it was mentioned like except the betting office, betting headquarters. Betting headquarters are four wall building than other varlam. See, the fifth one. There is no indication. There should not be an indication. They say onion, tomato, potato, and other vegetables except pachamalaga. Which means what? Pachamalaga is a vegetable, but still acts as non act because there is an explicit indication. There should not be a specific indication. If there is no specific indication, means then you can consider. See, if any word is there, you should not consider the word, right? Except the sort of word, the word consider பண்ணக்கூடாது சொல்லலாம். Okay, so we'll refer from the barrack. Okay, section 2, clause 64 talks about paid up share capital, or in short, you call this as share capital paid up. It's a means. What means what? Exhaustive list. Okay, such aggregate amount, etc., etc., received as paid up in respect of shares issued and also includes any amount credited, etc. See, you leave off all this. Go for this one, but does not include any amount received in respect of such shares by whatever name called. See, they say it clearly to say. Okay. Okay. So from the beginning, let me check whether I have left out anything. So where specific words pertaining to a class of category or genus, that's why the name generis, okay, are followed by general words. See, please highlight. List of words will be there, followed by general words. What are other vegetables? Vegetables is a general word. Onion is a vegetable, but specific word. Potato is a vegetable, specific word. But other vegetable is a common word. Okay. Followed by general word means the general word has to be understood, constructed as limited to the things of the same kind as those specific. Tomato தான் இருக்கு fruit அப்படிங்கிறதுக்காக you cannot add as a fruit. You cannot add other fruits. Okay. This rule applies with all these conditions. Yes, please highlight this one is quite important. This line, the rule of HSM generis is not an absolute rule of law, but only a part of the wider principle of construction. You may get it as code. Okay, but only a part of the wider principle of construction, and therefore this rule has no application where the intention of the legislation is clear. When you go for rule of literal construction, if that is clear, don't go for this one. ஏன்னா இது நம்மளே நினைச்சுக்கிறது தான். Okay. Exception. If the preceding term is general as well as that which follows this rule cannot be applied. If the specific term is general, I sell vegetables, I sell fruits. Like I cannot talk about anything. Fruits and vegetables only. They say tomato, but specific words are there. After the general words has to go. Then only I can apply. When the particular words exhaust the whole genus, no, you cannot take. Okay, completely has to talk about. There should be specific words. And is enumerated are essentially diverse in character, you cannot take. Okay. Where there's an express intention, you cannot take. Express intention means why we need to construct. It's expressive, right? It's following literal construction, you cannot take. Okay. You just go through. That's it. So, secondary rules, I'll continue in the next class. Thank you, thanks for joining.